Thank you, Representative Frank. You and I had a discussion yesterday on second reading about RFRA, the Religious Freedom Restoration Act. When that was passed, we involved a large number of folks from diverse religious perspectives to get everyone at the table. And we did the same when we passed legislation that allowed for religious providers and child welfare and other government services. And we did that so we could make sure we were crafting legislation as a body that didn't discriminate or favor one group over another, one religion over another. So my question is, in crafting this bill, did you work with Jewish groups? Did you work with Muslim groups? Did you work with the Anti-Defamation League to get their buy-in and input into this bill?
Well, I think you were asking about RFRA. I believe this bill is consistent with RFRA. I think it does prevent having to go all the way through the legal process to get through it.
And I'll have another question on RFRA in a moment, but that was just an example of how we brought people together to work on that particular bill. Did you work with those specific religious faiths and their advocacy groups in crafting House Bill 3859?
Yeah, we have had feedback from a lot of those groups.
Okay. Well, you know that
and again, in consistency with, we did use RFRA, which, as you mentioned, was worked on by a lot of people as the basis. This is consistent with that.
Sure. Well, I agree there's been feedback, but I don't think it's all been positive. I think the Anti-Defamation League, for example, opposes the bill.
Well, and in fairness, much of the feedback was based on an article that had very little basis in fact, and when the bill is actually explained to many of those people, I mean, it's one thing to react based on what words are printed. It's another thing to react based on fact. In fact, we had members in this body last night that were voting against it that realized, once they realized what it did, change their vote. This doesn't do what many people out there are saying it does.
So with respect to the Anti-Defamation League specifically, they sent an email to members yesterday stating their opposition. Have they since changed that and support the bill now?
I am not advised on that.
So as far as we know, they still oppose the bill?
I am not advised.
So with respect to RFRA...
yeah, which doesn't change what's in the bill.
Right. So with respect to RFRA, you said yesterday that this bill will help pick the winner of the RFRA balancing test. We talked about the balancing.
Yeah, and it probably is not the best word to use, but I think it makes it much clearer so that you don't have to go through all the way through the process. It allows a judge to make it very quick and give more certainty, because at the end of the day, what we're trying to get is more homes. And I don't think this prevents more homes from coming from any sector of society from coming to the table. This is current law. It just gives more certainty to providers so that they can open up more foster homes around the state. That's all we're trying to do here.
And I have a follow-up question to that with respect to current law. But if we're picking a winner, and maybe you're not using that language today, but I think that's what you said yesterday.
Well, and I did. I also said that was inarticulate. That was inarticulate. What I was saying, it declares RFRA is in effect in Texas. No need to litigate. That's so. I apologize that I used that word. That was inarticulate. What it says is, we have said this is a protected issue. No need to litigate. Get on to serving kids.
Right. So, but when we talk about picking winners, that's in terms of the providers that would be able to exercise their sincerely held religious belief under the bill.
Actually, we're not telling anyone.
To the child, right?
We're telling everyone that they can use their. We're not telling people who can use sincerely held religious beliefs. In fact, we're saying we respect all deeply held religious beliefs, including those that differ, and that really is the difference. We're saying everyone can have some things that they are not comfortable with. We'll make reasonable accommodations for all, and what I'm hearing is you'll make reasonable accommodations as long as you agree with everything I believe.
Yeah. No, I think the concern is that we've prioritized the providers' sincerely held religious beliefs, which may result in discrimination, and they may be the winner in this equation, but the child is the loser when we have children who need to be placed in home. I think
so you think the child would be the child would be the winner if we push these organizations out?
No, absolutely not. But
okay, so do you think we
there
should
is
make
a concern about taxpayer dollars going to organizations, giving them explicit permission?
Which has been done since the beginning of time and is not establishing a religion in any way, shape, or form. It's allowing people of all backgrounds to participate. That's all we're doing.
Right, but they're allowed to discriminate based on a sincerely held religious belief. And I think that is the concern, is that when there's public money involved, that they're allowed to do that under this bill. But if you say we're just, to move on, to say we're just basically codifying or reiterating existing law, if RFRA really provides these protections, as I believe it does,
okay,
and I think you have said it does,
and so this just shortens the process
why
to
is
give
the bill
certainty.
Necessary? So RFRA has not been successful?
It just takes a long time to get all the way through the RFRA process.
So under your bill, in section 45.002, at the bottom of page 1, it says that anything the government does, no matter how slight, can give rise to a lawsuit, and that any adverse action, direct or indirect, is prohibited. Isn't that correct?
Okay.
Is that correct?
You'll have to repeat yourself, sorry, if you don't mind.
The bottom of page 1, 45.002, says anything the government does can give rise to a lawsuit, that any adverse action, direct or indirect, is prohibited. Isn't that correct?
Yeah, that is correct. Okay. You're reading the bill, so I take it that you read correctly. Sorry.
Okay. I am correct on that, right? That's what the bill says? Any adverse action, direct or indirect, is prohibited.
Right. You're on page 1, line 21?
I don't have the line number, I apologize, but section 45.002, subsection 1, at the bottom of page 1 of the bill, yes.
Okay, it says adverse action means any action that directly or indirectly adversely affects the person against whom the adverse action is taken, places the person in a worse position.
Representative Burkett brings up a point of order. The gentleman's time has expired.
Mr. Speaker.
Point over the order is.
Mr. Speaker, I would move to. Mr. Speaker, I would move to extend time just to finish these last couple of questions.
Members, this is the first motion to extend time. Is there any objection? Chair hears none, so order.
So yes, what you just read is my understanding of what the bill says as well. So my question is, how does that not lead to frivolous lawsuits? If any government action, no matter what it is, could give rise to is prohibited under the bill. Yeah. So how does that not give rise to onslaught of litigation under this bill?
Well, I think the reason there won't be an onslaught of litigation is we have taken any monetary damages. What we really have is providers that are so interested in helping children that they're willing to sue to get back into the game. How is that going to be a frivolous lawsuit? There's no monetary damages. What they're saying is, we want to serve these kids so bad that we will sue to get back in it. How is that a problem?
Okay. So last question.
I mean, do you see frivolous lawsuits coming from that?
Well, I hope not. I hope not. But that is a concern when the language is that explicit. Any adverse action, direct or indirect, is prohibited. And so that's why I asked the question. And I hope it doesn't provoke an onslaught of litigation. So finally, we talked a little bit about this yesterday, but I wanted to bring it up because I think it's so important. So going back to RFRA, under current RFRA laws, they provide that a government can't substantially burden a person's free exercise of his or her religious beliefs. And that ensures, I think, that there are not frivolous lawsuits under RFRA, but that everyone is still protected. So if they need to seek legal recourse under RFRA, they are able to do so. And that's where the substantial burden comes in. And so, again, I come back to one of my original questions is, why is this bill needed in light of the protections under RFRA?
It really is to give quick, clear certainty to providers so that they can spend their time working with children instead of fighting lawsuits.